Honorable members, I'm going to make a ruling. I'm going to proceed to make a ruling on this issue. Respectfully, I have strong views against the flooding of the Supreme Court with appointments. I humbly submit that the line must be drawn somewhere to fix an upper limit in the interest of the rule of law and the democratic values. However, while the respected MP, Honorable Mahama Ayariga's concern regarding Supreme Court appointments warrant considerations, it is essential to recognize that the interpretation of the Constitution is exclusively within the domain of the judiciary, as I've already mentioned, specifically the Supreme Court. As a member of Parliament, no matter how distinguished, he respectfully lacks the jurisdictional authority to render binding constitutional interpretation. Although Honorable Ayariga's argument may or may not possess merit, it remains a subjective understanding of the law, susceptible to varying interpretations. If he is convinced of his position's validity, the appropriate forum for seeking a definitive and authoritative pronouncement is the Supreme Court, and not Parliament or its committees. Parliament's role is to exercise its constitutional mandate, unfettered by individual members. Legal opinions, no matter how well intentioned, allowing a preliminary objection based on a single member's interpretation, even if it is supported by subjective views of others, would improperly usurp the judiciary constitutional authority and potentially obstruct the legislative process. Therefore, as the chair should overrule the preliminary objection with reasoned arguments and proceed with the vetting process, ensuring Parliament's constitutional duties are fulfilled without undue interference. In any event, the respected Boko Central MP did not initially move a motion. He raised an issue asking that it be captured in the report of the House for subsequent consideration. Thus, he cannot subsequently seek to transform his preliminary observation into a motion demanding a vote at the committee level. If members want to move a competent motion, there are proper and competent ways of doing that. In any event, no rule relied upon to argue the supposed motion by the honorable member. If he still feels so strongly about this right, the right forum will be the plenary. This committee has no power to entertain a motion aimed at stopping proceedings. For emphasis, I rule that preliminary objection is hereby dismissed as same is without merit. Thank you very much. So, members, let's
Thank you.
please proceed.
Thank you.
Okay.
Chair, I respectfully reject the views you've just expressed. And let me say that we've gone beyond preliminary objections. This was a motion that was moved by the Honorable Mahama Ayariga and seconded by the minority leader, Honorable Atuforsen. And let me also emphasize that this appointment committee is closed with the power to make this decision. We have every right to make the decision, and the outstanding orders are very clear as to how we make decisions. And we have to make that decision. A motion has been moved. We have to vote on the motion, and we cannot simply brush it aside. You can't simply reject it by simply a speech. We are not ruled by just the whims and caprices of a chairman. We are ruled by the standing orders, and the standing orders are very clear. So, Chair, I return to the subject matter. We vote on the motion, up and down. In any event, I do not understand why the majority who have more numbers than us should be worried about it. Let's vote on the issue and make a decision on it, and then we can move forward. And I believe that is the fair. This committee cannot, and as you said, we respect the nominees. The reason why we are here, if you recall, we were here the last time because the same majority wanted to simply throw the rules away without advertising and allowing the people of Ghana to bring nominations. When indeed the appointment, as has been stated here by the president, is intended to simply fill a
let's all understand that the chair of the committee has given a ruling. It may not be pleasing to you. There are other avenues of you registering your protests. So we should just proceed. After the ruling has been given, we need to proceed and do the needful. Deputy Leader, with respect to you, going back to what happened before is unpalatable. All of us regret all that happened. The two leaders engaged profitably and well. And as a result, we mutually came to a date which was set ahead of time. 13th today was set ahead of time. And all of us came to speak in support of this. So as for that one, I'll plead with you. You have to stay clear of what happened in previous days, and so that we can respect the decision of the chair and proceed duly and conduct the vetting. So, Madam Chair, I am ready, if it pleases you.
Right. If the chair would grant me 2 minutes as well. Madam Chair, I totally disagree with your ruling. You have ignored the substantive issues raised by Honorable Ayariga, many of which you believe that it's a lacuna where we leave the law the way it is for presidents time and again to determine for themselves. And in recent time, the Chief Justice herself have joined the fray of setting the ceiling by endorsing the so-called limit as set by the president. I think your ruling is not. Yes, I can speak to a rule. I am surprised that the few minutes we came here, instead of us working together to see how we can move forward, you have gone ahead to unilaterally write your own judgment and I've decided to, yes, unilaterally, I don't know where you got the details from, to come and read to us. I believe, Madam Chair, that the issue about democracy ends up in one simple way: vote. After all the talks, after all the attempts to have compromises, when it fails, the easiest way out is vote. So whilst you have read your judgment, which is quite interesting, I would encourage you to climb down from your judgment to allow the pinnacle of democracy, vote, to take place. That is the only way we can find out whether we have taken a decision here based on the views of what Honorable Ayariga proposed and all of us, majority of us supported. Thank you.
Honorable members, please. I think we are going over this issue over and over again. And that we shouldn't belabor this issue. Please, I've given my ruling, because whatever argument you are putting out there, I haven't seen any basis in our regulation, in our standing orders, where you were the honorable, yeah.
I beg you, please.
Honorable,
I'm not, she says she hasn't seen any basis for moving a motion. So I want to show the provisions governing motions at the committee, and then also decisions at the committee. Yes, so order 2675 says that only members of a committee may vote or move a motion at a meeting of the committee. At a meeting of the committee. So a right to move a motion at the meeting of a committee is conferred on members. So yes, I started by raising what I said were fundamental constitutional issues that made me feel that it would be wrong to proceed on these nominations. And I articulated my position clearly. And then there were arguments. And based on the arguments that followed, supporting, cautioning, in disagreement, I felt that perhaps I should go the second leg, which was move a motion, because that is how you get a decision taken before any committee. You move a motion. So I moved a motion, which is clear, order 2675. Now, the next thing is to put the matter to a vote, which is also governed by order 284. There's no provision for a ruling by the chairperson. There's no provision for a judgment. Because it is not a preliminary objection that I was raising. I raised an issue and I followed it with a motion, because that is how you move a committee to take a decision. So if you say you won't put it to a vote, Ghanaians are watching. But to say that by giving a ruling you have ended the matter, with all due respect, that is not a procedure known to our standing orders.
Madam, let me make a point here. Madam, respectfully, you are completely out of order. You are out of order because the rules does not allow you to make a judgment of this nature when you are chairing a committee of parliament. Your ruling is not grounded in our standing orders. It's not grounded. In fact, the conduct of a committee of parliament is clearly stipulated in our standing orders. And as Honorable Ayariga rightly said, Order 267, scope of deliberations of committees, scope of deliberations of committee. Order 2675 clearly states that only members of a committee may vote or move a motion at a meeting of the committee. The Honorable Mahama Ayariga is a member of this committee. He is not a stranger. He has moved a motion we have moved. In fact, the train has moved from the station. The train has moved from the station. All what you can do is to put it to vote. Madam, as for the voting, today the vote will happen. We will count the numbers. We will count it in accordance to Order 284, voting of committees. 284, voting of committees. A decision at committee shall ordinarily be by consensus, or where a committee is unable to reach a consensus, the decision shall be by majority vote of members present, either by voice vote or by head count. And 3 goes on to talk about when there's a division and how that division must be taken. You cannot change the goalpost and reinvent a new standing order, which is alien, a provision which is alien to the standing orders. So just like you have said, I now challenge you to show us where in our rules that you can say that you because somebody, a member of the committee has moved a motion, you brush it aside and then you come with your ruling. Show us where in the standing orders that gives you that power. You have no such power. Madam, you have no such power.
The reference backing his ruling. Whether the Constitution or the standing, we are waiting her reference.
Honorable. Yes. Do I see the hand of the majority leader? You can participate in the meetings.
Yeah. Madam Chair, thank you so much indeed. Respect. That is correct. My respected colleague, the minority leader, colleagues in leadership of the minority, and colleague members of this respected committee, I believe that in all of our actions as parliamentarians, we aim at ensuring that we build consensus, ensure that we conduct our actions well-founded on the Constitution and other rules guiding us. I have listened to the views expressed, and I would want to express a view, and in all modesty, I shall proceed as follows. Madam Chair, first, the argument of my respected senior at the bar and colleague member of Parliament, Honorable Ayariga, was to the effect that a constitutional provision is being breached, and on the basis of that, he raised a preliminary objection. In law, what at all is a preliminary objection? When a person comes up with a view, the nature of which he will tell me that's preliminary objection, what he's saying is that ab initio, that body has no mandate at all to proceed. Now, if the chair takes a decision that no, there is a mandate to proceed, proceedings would have to continue without unduly frustrating same. However, as I heard Honorable Ayariga correctly, he said that having taken that initial step, he now moved a step further to move a motion. Which motion, in his view, a decision would have to be taken upon. But, Madam Chair, we are all in this house. How a preliminary objection can metamorphose into a motion is one thing that we would all have to consider. We know when we use the word a decision in Parliament, what we mean. When we use that word a decision, we know what we mean. What do we mean as parliamentarians when we talk about decision? A decision is raised as a term of art in parliamentary parlance where there are deliberations, or we have come to the end of our deliberations. And at the end of the deliberations, a member is required to move a motion, which motion is to adopt the report, a decision, and it has to be seconded. So the decision as used in the context of our rules is to the effect that we are done and we must bring our deliberations to a finality. That is where it is either by consensus or by head count or what we all know, maybe majority decision, where en bloc, a group will say that we are opposed, so we are voting en bloc. Then it becomes a majority decision, or there's a head count. And I have looked at the order 2675, which, rightly so, has to do with decisions of the committee, which decisions will come as a result of a finality in terms of deliberations. Now, if you look at the voting at committee, a decision at committee shall ordinarily be by consensus. I beg to submit, in all modesty and with the greatest humility and utmost respect, to my very senior, who is a Harvard scholar, and he knows how much I respect him. We've worked at ECOWAS Parliament together. I've taken a lot of his mentorship. He's guided me on a lot of matters. So, Leonard, most respectfully, the voting at committee, as contained in Order 284, is where we have come to an end of our deliberations. The matter before us, again in all modesty and with the greatest respect, is not a matter for decision. It's a matter that the honorable member himself, in his own way, said he wants even the committee's report to reflect his objection. Now, if we go on the floor, the plenary, if the committee is able to conclude on the deliberations and we get to the floor, that argument can still be made on the floor for Mr. Speaker's determination. And this is not the first time that, as a House, we've taken a decision and subjected it to certain conditions. So, Madam Chair and colleagues, my view is merely persuasive. In fact, I don't have any right to vote. You've only granted me that special privilege as your leader to express a view. I would humbly plead that we respect the ruling of Madam Chair, however displeasurable it may be to us, and in all humanity, proceed to vet the nominee. In any event, Mr. Speaker had made a referral to us. And when the letter came and the referral was made, there is no record at the plenary to the effect that a preliminary objection was raised in respect of the constitutionality or otherwise of the said communication from Mr. President. I know that yesterday the Honorable Minority Leader even requested for evidence of proceedings at the Judicial Council, evidence of letter nominating and all that. I labored all day to ensure that he gets that information so that he would be able to make some informed decision. So it's my very humble view, and we don't need to threaten each other or, raise our voices. This is democracy, and the beauty of it is that we express our views and move on. We will not end vetting today. Tomorrow, we would have you in the reins of government. Another time, we'll be in the reins of government, and we would have to always ask ourselves that in all our opposition and objections, the ship of state would have to sail. And democracy also allows for mistakes, which mistakes are to be corrected through the appropriate means. So whatever that happens today would not be a finality. But we as a political class must demonstrate that even where we disagree, we will not use that to stampede a process, but allow a system to flow so that the nominee who is seated right by us will not feel so embarrassed or intimidated.
Chairman,
Madam Chair,
the chairman.
Madam
see,
Chair,
I respect him as the leader of the house.
Chief Whip.
But he's spoken even longer than everybody.
Chief
here.
Whip, I'm begging you.
I mean,
Chief,
how can you?
Honorable
Why do you grant him
Chief
that?
Whip,
Because I
I'm
have a
beg-
serious matter to raise.
Chief Whip,
Yes.
I am begging you. You know I always beg you. You know how I always beg you because your views have always been very superior. You know the difficulty I find myself. You know, only yesterday you were my best friend. If you are trying to be a former friend, that's okay. But I shall remain a good friend. You know, and I know that my namesake would have to come to my rescue, and he will come to my rescue. Thank you very much, sir.
Yes,
No, my namesake is Honorable Atu Fosun.
Leader, I want to raise a very serious issue. The ruling you read, I just noticed that this ruling was posted on a Facebook page of a known journalist an hour ago. What's his name? And I can tender this for the sake of the protection of the person. It will be extremely damning that the ruling you have given did not come from you, because you remember I made a comment that within a short period that we left here, you were able to, in fact, you were with us in the room after a point in time, you were able to put together this very comprehensive rule. I can read out what is on the social media page of the journalist if you want me to. Do you want me to read it? This is unacceptable. This is scandalous. Unacceptable. A serious committee of parliament, and you read something to us that is supposed to be coming from you. I feel scandalized.
I plead, Chair, if you may, just a minute. Kwame, with the greatest of respect, this is a very serious allegation. I was with her when she was writing. Please, it's enough. It's enough. Madam Chair, you have given a ruling. They have.
Let her tender.
I am not the one chairing the.
Can she tender what she
Kwame,
read?
can
Let
you
me
listen
compare to what.
No, you cannot push the chair to tender what she read. No, you may have your objections, you may have your views on her ruling. That's fine, but she has put finality on the matter. The powers of a committee of a chair is well defined in our standing orders. Madam Chair, I have repeated. Madam Chair, I need your attention, and you have to protect me. I'm a very important member of this committee. I also bear institutional memory. Please, can I proceed with the vetting? I have very good questions.
We are talking about a fundamental problem here, where the ruling given by the chair appeared on the Facebook page of a journalist an hour before she read it here. 1 hour before she read it here. It's a serious matter. This committee must be taken serious. It is a serious matter. So I recommend, Madam Chair, tender what you have actually written according to the Chief Whip to the clerk, so that we shall tell you what you read is exactly what is on the Facebook page of that.
I thank you very much for the opportunity. Honorable nominee, let me commend you highly for your nomination.
Madam Chair,
my
Madam Chair,
first question
Madam Chair,
to you
Madam Chair,
is to
we have to
find
know
out
what we are proceeding
your
on.
judicial
We have to know what we are
experiences
proceeding on. We have to
that
know
has
what we are.
prepared you.
Honorable, please.
Honorable nominee,
please,
I'm
please,
seeking
please.
to find out
This
your
is
judicial
not-
experiences
Excuse me.
that has
excuse me, Chief Whip.
prepared you adequately
I mean, you are
enough
starting vetting.
to be at the apex court. Will you share with this honorable committee, please?
If honorable nominee, the chief whip is just a member of this committee. He has no right to direct you to speak whilst you are here. So, Chair, rule him out first. And I've made a serious allegation against you that the ruling you have given appeared on a Facebook page of a journalist an hour before you did that. Address that one first. It's a serious matter. Address that one first. She wrote it and posted it to the.
You have requested for that, and it will be part of the submission of papers to them.
True. Did you send it to a journalist 1 hour before?
All members,
Can I proceed?
I think we have it in our order 268, subsection 3, that the chairperson of a committee shall maintain order at a meeting of the committee and decide on each question of the order. I wonder where you are coming from to say that the chairperson doesn't have that locus. It is right in your standing orders. I have given my ruling. We are going, please proceed to take the questions on.
I'm saying that is not your ruling.
It's okay.
It is not your ruling.
It's okay.
Because you couldn't have posted your ruling is, I'm saying your ruling is illegal because that ruling couldn't have appeared on the Facebook page of a journalist 1 hour before you have read it. You would have been a miracle maker to be able to do that.
Thank you for the.
So your ruling is null and void.
Let me commend you highly again for
More than that, Madam Chair.
nominees being nominated
Madam Chair,
by
more than that,
Excellency
Madam Chair,
the President.
more than that,
Um,
you have not
my
addressed,
first
you have not
question to you
addressed, you
is
have not
final.
addressed the fundamental
Your
issues that were
judicial
raised,
experiences.
which has to do with the standing orders
Do you
and the
consider
fact that
your
there's a
judicial
motion on the floor.
experiences as good enough to have prepared you to serve at the Apex Court?
Honorable, I have quoted that standing order. And yes, please, I call for the
Honorable
order.
Chair. Honorable Chair, if I get your question, is how well am I prepared to be a member of the Apex Court if it's approved? Please, was that the question?
Madam Chair, Madam Chair.
You do not want this vetting to proceed. You have brought the Supreme Court nominees. You, the government side, have brought the Supreme Court nominees here to be ridiculed. Because all the actions you've taken from the very first day they were nominated show that you don't give them respect. If you give them respect, the chair will not sit in this chair. And I'm telling you, she read a judgment that she plagiarized. And then the Supreme Court judge nominee is talking about that. And I've said the bigger issue, the second bigger issue that a colleague have moved a
That you
motion.
also want to preclude them from being in the
There's a motion, a competent motion on the floor. We are telling you, you do not have the right to rubbish the motion. And you are still going ahead.
Answers. My question was simple. I am eager to understand
Mr. Chairman,
your
please, I want to
judicial
make a very
experiences
fundamental. Mr. Chairman, I want to make a fundamental.
over the
statement.
years, whether it is
I am. I'm not a friend of the
enough
committee. I'm a member of the committee.
as
Please, I'm not a friend.
preparatory ground
No, but I want to raise a fundamental issue.
for
Please.
you to serve at the Apex Court.
She has to call you before. Put up the mic.
Yeah, Chairman.
She has to call you before. Stop.
Chairman, do I have your? Let me.
Put it up.
Chairman.
She has to call
To just bulldoze your way through. I don't think that the nominee want to entertain that. The nominee should be worried that at this committee, even the things she's seeing here don't appear to be wholesome. It's a serious matter. Imagine the Supreme Court judges reading judgments that have been borrowed from somewhere else.
Until you put the motion to a vote, there will be no vetting. And if you want to disrespect the rules of Parliament, and members of this committee, well, let's do it. But we are not going to throw the rules of Parliament away. There's a motion on the floor. No. And we are going to vote on that motion. No rule.
Who doesn't have a right? You bring the goodness into order.
Madam Chairman, Madam Chairman, Madam Chairman, please, let me, please. Madam Chairman, please, let me make a very fundamental
Madam Chairman. Chair,
Madam Chair,
I'm making a very, yeah, Chair, I'm making.
You are not speaking on mic. You are only making the
Yeah.
whole place unruly. So
Chairman.
let the honorable member.
Good. Yeah, thank you very much, Chair. Chair, I'm very grateful for, Chairman, thank you for, please, colleagues. Please, honorable colleagues, please, honorable colleagues, let's listen to one another, please. Madam Chair, thank you very much. Madam Chair, we are here again because I think we are getting some things fundamentally wrong. I feel very embarrassed as an officer of the court to see a very learned judge sitting right before us, and we doing all kinds of I don't know how I would even describe what is happening here. Now, the whole world is looking at us, and it's very embarrassing. And that's why I warned from the beginning that we can save all of us this acrimony by simply following the rules. And I recall that one of the reasons why we went on a break was to build some consensus. And all the conversations that we had for purpose of consensus, once we are unable to reach consensus, I believe that we follow the rules to the letter. In fact, when we went to conclave, the understanding we had before we came back was that this was going to be put to a vote, and that only members of the committee were going to vote. You see, but once you get here and that consensus turns into a ruling, then you bring about the acrimony again. So please, very, very respectfully, I think we can end this by just doing the needful so we can save all of us this embarrassment. That's my respectful submission.
No, I'm on the line. Let me say something. For a long time now, you heard from me. Thank you very much. Madam Chair, for your guidance. Please. No, not that. She should be fair for what? I mean, listen to us. Please, I'm on the floor. No, you are spoiling the meeting. Madam Chair, please, Minority Deputy, please, I'm on the floor. Madam Chair, I'm on the floor. For your guidance, we have practice directive. If it is in the High Court, Madam Chairperson, you will listen to me for guidance. It will help us a lot. Please. Leader, no, I'm talking. Can I put it off?
He's being distracted by the
majority leader, and I'm just pleading. Madam Chair, I'm saying that let us be guided. If a matter arises in the High Court, and then the issue of a constitutional interpretation comes into play, what the High Court judge will do is that he will defer proceedings of the matter and refer the issue of constitutionality to the Supreme Court for interpretation. He doesn't continue with the case while the controversy of whether it needs constitutional interpretation or not is in place. I will humbly plead with you and our colleagues here that once the Honorable Ayariga has raised an issue where you say that, well, it is a matter of the constitutional interpretation by the Supreme Court, then what you should do is to defer proceedings of this matter. And then the matter will be referred to the Chamber and to the Supreme Court for interpretation. It is not only in the court, but even in Parliament here, where some have been here for donkey years. Look, you go to a committee, if there is some information that they are not privy to, or they want it is not available, they suspend proceedings until that information is received. You are aware about it in all the committees. So we are saying, what we are saying, Ayariga is saying this morning is that, as far as we are concerned, there's a controversy. So we are saying that let us defer sitting. Let us suspend sitting until we resolve this issue in one way or the other before we come and then proceed. But to arbitrarily overrule a motion that has been seconded, it is unheard of in any democratic dispensation that a motion can be moved and seconded and then you write a ruling. The ruling is not in place. It is out of place with the greater respect to you. And to the majority leader, I think that he had labored for so long but that does not refer or relate to the matter that we have in issue. I appreciate his industry, but the industry.
Madam Chair, just for peace to prevail, I think that sometimes we can take certain steps to resolve. If members want to proceed on the motion, I think that I respectfully submit that you may grant that so that you take the vote instead of proceeding without the vote. So, Madam Chair, please grant the pleasure. Thank you.
Madam Chair, under what I said proceed. Listen. You see, no, hold on. The leader, the respected, listen to me. The respected leader in this meeting is a friend. The way he spoke does not connote a friend to the committee. He spoke as if he's directing the chair to take a decision. The same decisions we members of the committee persuaded her to take, and she refused. How come a friend of the committee is directing her and she's about to do that?
Respect to you. The leader is not, emphasis mine, he is not. Minority leader will bear me out. We related, even before we sat, we related just for us to engage and find a peaceful avenue in this matter. So this is originally not even coming from the leader. No. So may I suggest, as a member of the committee, I'm sure this time you will listen to me. May I suggest that, Madam, you accede to their call, and then we take a vote on the motion moved by the Honorable Ayariga, as was requested.
I find it very interesting that all of us were asking for the same thing. It wasn't granted.
Honorable members, in order to take the votes, I need to make it clear who are members of the appointment committee. Members of the appointment committee, as stated in our standing order.
Honorable, it is important for her to quote the specific orders. We are members of parliament.
And we have our list to determine who is a member of the committee. And then we have Honorable Joseph Osebusu as the chairperson, Honorable Patricia Pede as the vice chair, and then we have Honorable Frank Anodombra, a member, Honorable Eve Hansen Norty, a member, Honorable Yevil Baligi Bache, and then we have Honorable Dr. Kesli Atumba Fawcett, ranking member, Honorable Emmanuel Ama Kofi-Boa as a member, Honorable Kwame Governs Abuja, Honorable Mahama Ayariga, and Honorable Dr. Agnes Na Momo Lati as members. So, Honorable Gifty Chum Ampofo, I'm sorry for missing your name, as a member of a year. So, you know, we are going to do it by show of hand. Those honorable, so the members of the committee have been decided on. These are the members of the committee, and then we are going to take the votes. Yeah.
Chair, please. Chair, please. Yes. Please. Just to draw your attention, I have to address your mind to the new standing order. And I'm referring you to order 2174. No, read the 217. So, 217. The Appointments Committee comprises the First Deputy Speaker as chairperson, the Minority Leader as the ranking member, the Deputy Minority Leader as vice chairperson, and the following other members: Deputy Minority Leader, Majority Chief Whip, Minority Chief Whip, and 3 other members selected based on the numerical strength of the parties in Parliament. Let me take you to number 4. Well, let me continue. 2, the leadership and 2 other members of the relevant subject matter standing or select committee shall join the members of the appointment committee to consider persons nominated by the president for appointment as Chief Justice and Justices of the Supreme Court, Ministers of State, Deputy Ministers, and the Administrator of the District Assembly's Common Fund, the Special Prosecutor, and other persons specified under the Constitution or any other enactment. Now 3, where there is a realignment of ministries, membership under Rule 2 may be composed in a manner to reflect the realigned ministries, except that the membership of the Appointments Committee shall not exceed 15. But let me take you to the very important point that I want to, I think you missed that. And it's 2174. Despite rules 5 and 6 of Order 267, which talks about the scope of the committee, a member of the relevant subject matter committee shall exercise the same rights as the member of the appointment committee.
That's it.
And let me take it again. 2174.
Yes.
Despite Rule 5, 6 of Order 267, a member of the relevant subject matter committee shall exercise the same rights as the member of the appointment committee. In plain language, the subject matter committees that are here have the right to vote. And I think it has to be clear. It's clear in our newsstand orders. It's clear in our news.
Madam Chair, Madam Chair, let us, can I make the point? Madam Chair, I think that we need to proceed with good faith. Good faith. In good faith. You see, if we are members of parliament, we are building consensus in a matter. We don't have to now interpret the rules in a manner that we think will suit us. No. I think that we heard you. First, we are dealing with an issue of decision. A decision. Not an issue of emotion. Then we jump from there to membership of committee. Now, wait, let me make the point. Look, let me make the point. How is the chair allowed to pretend? If a chair makes a ruling, you say no, so you would want to be disruptive? Or when the chair takes a decision that you are not happy about, you say, no, I'm making a point.
With all due respect, I've just read the standing order. We've not heard from the chairperson. Let the chairperson respond. No, let the chairperson respond. You're not chair.
Let
the chairperson respond.
No.
No,
stop.
I think you are missing it. You are missing it. Leader, you are missing it. You should read your standing orders very well. Read your standing orders well.
2 other members.
No, the leadership and 2 other members. Don't get it wrong.
That's what it is.
The leadership and 2 other. Read the standing orders very carefully. It's the leadership of the Judiciary Committee and 2 other members.
The leader was on the floor. Let's allow
So
him.
don't.
Two other members.
Leadership and 2 other members.
On order. Mr. Chair, Madam Chair, let me read order, colleagues. Let us not deliberately. Madam Clerk, please, I'm on the floor. Madam Chair, please, the membership of the committee, Honorable Amakofibwa read it, and then let us go to the rules. This is what it says, 2171. I will read the entire provision. The appointment committee shall comprise the first deputy speaker as chairperson, minority leader as ranking member, and the deputy majority leader as vice chair, and the following other members. A, deputy minority leader. B, minority chief whip. C, B, majority chief whip. C, minority chief whip. And 3 other members selected based on the numerical strength of the parties in parliament. That is the first leg. Second leg, the leadership and 2 other members of the relevant subject matter standing or select committee shall join the members of the appointment committee to consider persons nominated. No, we are not. By the president for appointment as Chief Justice and Justices of the Supreme Court, ministers of states, deputy ministers, the administrators of the District Assembly's Common Fund, the special prosecutor, and other persons specified under the Constitution or any other enactment. 3, where there is a realignment of ministries, membership under Rule 2 may be composed in a manner to reflect realigned ministries, except that the membership of the appointment committee shall not exceed 15. Shall not exceed 15. Colleagues, let's pay attention. Shall not exceed 15. Per our rules, whenever there is an odd number being the upper limit or the total number of committees, we have 1 majority. Whenever it is even, the committee membership is even, we share it equally. There should be no issue of
Clarify it.
Well, yes, I'm
just
saying,
not whenever.
Yes,
It's because on the appointment committee, for example,
yes.
we are more than you.
No.
And
I'm
you
saying
even
that.
when it
No,
does.
hold
So
on.
it's not with us.
Let me make it. That's yeah, no problem. So what I'm saying is that on the appointment committee currently, we have 8 members. You have 7 members. Yes, we have 8. You have 7, making it 15. We know for a fact that Honorable Joe Wise, who is the chair, is unavoidably absent. So currently, as we said, we have 14 member committee. In fact, this has been the composition since you started vetting, So I think that there's no confusion. I have listened to the other provisions which were read by Honorable Amakofibwa to the effect that other members have equal rights. So there's no problem. Other members have equal rights. So if we proceed on the 7-7, but Madam Chair,
We have
it's
to-
7, Mama Pat, it's 7-7. It's 7-7. Let's proceed. It's 7-7. So now the motion on the floor, we all know. Again, since now the experts of the rules are here, the motion on the floor is whenever you are moving a motion that Parliament should not proceed, this committee should not proceed. So right now, when there's a tie, it means that the movers of the motion have lost. No, you know already. Oh, please, I beg you. Oh, God. Oh, please, I beg you. Oh. So they want to kill me. It's okay. Madam Chair, this is your baptism of fire. Baptism of fire. That is it. So on that basis, Madam Chair, let your members, those who are in for the motion would rise. Those who are against will rise. Then
Madam, apart from to say that this process must be conducted by the clerk under order 284. So don't do it. Let the clerk do her job, please. Under order 284. Please.
Honorable member.
And use the standing order.
Uh,
You use that. Proceed, please.
And make sure you get a copy of her ruling.
Honorable, I'm going to call on the clerk of the committee to undertake the voting.
Yes.
Please.
Thank you, Madam Chair. And Madam Chair, respectfully, with your permission, I'll proceed by mentioning names, and then when your name is mentioned, you vote yes or no. Okay. So, Honorable Joseph Osei Wusu.
Madam, please. We don't vote only yes and no's. We also vote in abstention.
Okay.
So please, correct. That's why I referred you to the standing order. Please go. Somebody may abstain.
Respectfully, thank you for that. So we're going to vote either yes, no, or abstinence. 3 options. Honorable Patricia Apieje. To the motion. Honorable Frank Anadompre. Honorable Gifty Chum Ampofo. No. Please, kindly speak to the mic, madam.
No.
Thank you. Honorable Yevil Balige Bachi.
No.
Honorable Yves Hansinoti.
No.
Honorable Dr. Kaso Atuba Forson.
Yes.
Honorable Governor Kwame Agboja.
Yes and yes.
Only one. It's only one. Honorable, please, 1. Honorable Emmanuel Ama Kofi Boa.
You sabotage me, eh? The thing's not working. Yes.
Honorable Mahama Ayariga.
Yes.
Honorable Dr. Agnes Na Momulate.
Yes.
Honorable Idi.
No.
Honorable Kojo Asante.
No.
Honorable De La Soa. Honorable Cletus Avoca.
Yes. Oh.
1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. No. To the chair. Okay. Respectfully, I'll give the collated results to the chair to announce.
What about, Madam, the other members of the committee? Have you announced that?
Yes, they've all voted.
No. Madam Chair, I am one of the 2 other members of the Judiciary Committee here, and by the standing orders, I have equal rights as committee members when it comes to the subject matter.
Honorable member, we have two members from the minority side who are representing the judiciary, and that is where we are. We don't have. Honorable members, he's not a member. We will exceed the 15 number, please. Honorable, no.
Madam Chairperson. Madam Chairperson.
Madam Chair, very respectfully.
Honorable.
Madam Chair, very respectfully. Very respectfully, Madam Chair, this is what the rule says. Respectfully, Madam Chair, this is what the rule says. Madam Chair, can I kindly refer you to the rules?
Honorable member.
Let me refer you to the rules.
We were very clear.
Madam Chair.
And this committee can never exceed 15 members.
Madam Chair, please, can I refer you to the rules?
The 4 is 15, and it's period.
But can I refer you to the rules?
No, please. We have gone through the rules.
No, Madam Chair, let me refer you to the rules.
Which rule?
Madam Chair, the rule says that order 217.
Honorable, you are out of order. Please.
I've been denying my right here.
No, you don't have any right.
No one is defending my right here.
No.
I have a right as a member of the Judiciary Committee to vote on this matter. I have a right to vote on this matter. I have a right to vote on this matter, Madam Chair.
Honorable, so far as this committee is concerned, there's a motion on the floor. We voted on the motion, and we have 7 yes and 7 no. We don't
Without
have
my vote?
Any abstention, and in view of that, the motion is lost on
one denial. Let the record bear this. Let the record be clear.
Result on the website of this.
On that basis.
So on that basis, we are proceeding with the vetting.
Okay,
so I'm going to call. We haven't even asked the member to.
It's okay. Let's proceed. Okay, so.
Can we proceed? We've had a very long day. Can we proceed with the vetting? Thank you very much.
Get all your reliable news items here on Sweet Melodies.